I got you. Court does call the case of the people versus Cassie Colley.
Foley.
People.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Colley. Ms. Colley, state your name for the record. You didn't already.
Cassie Coley.
Foley.
Your Honor, you should have a plea form in front of you with a signed advice of rights form.
All right, I have a plea form that indicates that the defendant would be pleading guilty to retail fraud second degree, the 1-year offense. Upon a successful plea to that charge, count 1 would be dismissed. She agrees to pay restitution as ordered. That's the entire understanding of the.
That's correct, Your Honor. That is our understanding as well, Your Honor.
All right, ma'am, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
State your name again, please.
Cassie Lynn Coley.
All right. Ma'am, it is this court's understanding that you are going to be pleading guilty to the charge of retail fraud second degree. That is a misdemeanor punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become your maximum fine. You understand that?
Yes, yes, Your Honor.
And they already do. I need that one shut. Do you still wish to plead guilty?
Yes, Your Honor.
And to that charge, how do you plead?
Guilty.
Now you understand that by pleading guilty, you will not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form or gave permission to sign that after going through it with your attorney?
Yes, Your Honor.
Do you have any questions regarding those rights?
No, Your Honor.
You understand that you're giving up your trial rights as contained in paragraph 5, as well as all the rights that are contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily and of your own free will?
Yes, Your Honor.
And also because you believe that you're guilty of this offense?
Yes, Your Honor.
December 16, 2020, at the location of 3825 Carpenter Road in Pittsfield Township, Washtenaw County, State of Michigan. What did you do at the Meyer store that makes you think that you're guilty?
I took some items that I did not pay for, Your Honor.
All right. And you tried to walk out of the store without paying for them?
Yes, Your Honor.
Store was open to the public at the time?
Pardon me?
Was the store open to the public at the time?
Yes, Your Honor.
You didn't have anybody's permission to take that property, did you?
No, Your Honor.
And the property you took was property that was offered for sale by Meyer?
Yes, Your Honor.
All right. Is the second based upon value?
Yes.
All right. Was the aggregate amount or the total amount of the property that you took, was that in excess of $200?
Yes, Your Honor.
Conflicting stories unfold. She insists on her truth. Defense points to missing details. Scratches captured in photos bolster her claim. Judge rules trial must continue. The fight for justice begins.
Ma'am, if I accept your plea, I have to advise you that if you commit misconduct as defined by the Michigan court rules between the time of my acceptance of your plea and the time of your sentencing, that the court would no longer be bound by any sentence evaluation or recommendation in the case. You understand that?
Yes, Your Honor.
You also would not be permitted to withdraw your plea. You understand that?
Yes, Your Honor.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, sir.
No, Your Honor.
And have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be
September 24th at 9 a.m.
So we can't do the
October
20.
8th.
Because I need 2 weeks if she's gonna be by Zoom. October 8th?
Yes.
October 8th, 2025, 9 a.m. That's before me. Found will continue.
I do have one thing, Your Honor. Miss Foley is
Go
in,
ahead, Verity.
thank you, Lenawee County.
Really? Yeah.
There were warrants issued because I believe failure to appears. They submitted her social worker from Lenawee County PD submitted warrant recalls. Your Honor set these dates but kept the warrants in place. She's has approval to go to Bear River, but these are holding her up. So there's this case, and then there's 2 misdemeanors scheduled for the 17th before Your Honor, where there's still warrants. So I'm asking that the court recall the warrant in this case, or all 3 if possible.
She will be in Lenawee the entire.
Well, she's in Lenawee, but she has a release to treatment there. So as soon as these warrants are resolved, she'll be released to Bear River from Lenawee.
In this case, it's before me. I will cancel the warrant. I'll reset her bond at a personal recognizance. $5,000 personal recognizance bond. In the other matters, I suggested you communicate with Ann, and
Okay,
we'll see what we can do on that.
thank you.
Thank you. Thank you, ma'am.
Thank you.
Court does call the case of the People versus Jennifer Lindsley.
Morning, Your Honor. Raymond Cook, the People.
Good morning, Assistant Public Defender Lauren Perny on behalf of Ms. Lindsay. Ms. Lindsay, please state your name for the record. Ms. Lindsay, you're muted. Is there a officer that can unmute your device?
That was a no. Did she sign?
Jennifer Lindsay.
Wow, she was right on time.
She signed?
Your Honor, we're asking for an exam date, please.
All right. Discovery is complete.
Yes, my knowledge.
And what facility? She's at Huron Valley, so we could do, I think. If she's at Huron, that'll be enough time for her. Will the people have their witnesses available September 30th?
Yes, Your Honor.
Preliminary examination in person will be set for September 30th, 2025, 9 a.m. That is before Judge Washington. Bond will continue.
Thank you.
Thank you.
We'll be in touch with Ms. Lindsay.
Thank you.
Court does call. Thank you. Court calls the case People versus Terry Probst.
Yes, sir.
An Assistant Public Defender, Natalie Pate, with and on behalf of Mr. Probst, who appears via Zoom from the Monroe County Jail. Sir, can you please state your name for the court?
Terry Allen Probst.
Your Honor, I have followed the instructions on the Monroe County Jail's instructions to schedule a video visit with my client. I do have an online account created in the system. I do have the facility added. I do have my client added. It is pending approval. So I'm asking for an adjournment. If that is not approved by sometime early next week, I plan on maybe just showing up there in person and seeing what has to happen.
The end? What?
Asked if I can see them. They might be fine in person. I don't know.
Okay. How long, sir? How long do you do you have a release date? I guess
No, Your Honor. Right now, I'm supposed to go to court on the 15th, which is Monday.
Got it. Okay. Well, why don't I do this? Why don't I set it for the 9th, like the last one? If he gets out, then he can appear on that day. All right.
That sounds great, Your Honor. Thank you.
Probable cause conference will be set October 9th, 2025, 9 a.m. Bond continue.
Thank you. Thank you, Mr. Probst. I'll talk to you one way or another.
Yes,
There
ma'am.
was a bench warrant for his failure to appear.
Yes, sir.
That is-
Your Honor, I was in court. I was in here at the time of that bench warrant was issued.
Got it. What I'll do on that is I'll cancel the bench warrant and reinstate his previous bond.
Thank you very much, Your Honor.
Thank you, Your Honor.
Thank you, sir. Court does call the case of the people versus Ardeen Henderson.
And for another for the people?
Brian Bowling on behalf of Ms. Henderson. Ardeen, can you state your name for the record, please? Honor, but she did not know what would happen with that case, so and I don't think she's going anywhere for the foreseeable future.
All right. You want the 30th or the 9th?
Let's do the 30th.
Probable cause conference, September 30th, 2025, 9 a.m. Bond continued.
Thanks, Judge.
Court does call the cases of the people versus Ronald Sims.
In testimony's heat, fear speaks louder than memory gaps. Defense demands clarity. Prosecution leans on photos. Judge finds probable cause. Justice is set in motion, waiting beyond today's ruling.
Good morning, Assistant Public Defender Lauren Perny on behalf of Mr. Sims. Mr. Sims, state your name for the record, please.
Ronald Sims.
So, Your Honor, there are 3 cases before you.
There are.
We are asking for exams in all 3. I will note for the record, because I know what question you're going to ask. 2 of the cases we do not have media discovery on. I've spoken about this with Mr. Sims at length. He would like to set them for exam, knowing that he would not get an adjournment if we do not have it by the exam date.
Is that really what you want to do, sir?
Yes, Your Honor. We'll do that. It just brought to my attention that it could be my Miranda rights as well. So that's one something, or we can do that after, later, the next court date. Okay. Yes.
Which 2 do you not have media on?
The I don't know the case numbers off the top of my head.
Okay, give me charges.
Largely from a vehicle, we have media. On the other 2, we do not.
So the B&E vehicle you do not have or do?
Okay, in the case ending in 5717, we do.
5717 you have. Oh,
Yes. The other 2, we do not.
all right. Fair enough.
Let's see.
People have their witnesses available the 25th. So 12 days out. No, let's see. Well, what's my day? 23rd. Got it. I guess I should say it's September 23rd, which you have people available. Council. 23rd. Well, that preliminary examination in person will be set for September 23rd, 2025, 9 a.m. before Judge Barr on all 3 matters. Bond will continue.
This time.
Court calls the case of the people versus Brandon Bellotti.
Ready, Your Honor.
And was that on behalf of people, Your Honor?
Good morning, Your Honor. Joe Simon on behalf of Mr. Bellotti.
Her name?
Brandon Bellotti. Requesting a preliminary exam, Your Honor.
Discovery is complete.
It is, actually. It just got complete, Your Honor. It just happened.
Sounded like a shock.
Well, recency, Your Honor. Recency.
Would the people have their witnesses for the 23rd?
We'll do our best, Your Honor. Your Honor, if I could ask the court to amend complete the police report number that's listed is incorrect.
Hang on 1 second. Preliminary examination in this matter will be set for September 23rd, 2025, 9 a.m. before Judge Judge Freshour. His bond will continue, and you needed the complaint amended to,
Your Honor, the police report number is AAPD 25-37347 rather than 437.
37347 is what it should read.
Correct, Your Honor.
Voices rise. Arguments clash. She recalls choking. Defense doubts her clarity. Prosecution insists Marks tell the story. Judge agrees there's cause. A trial awaits where silence and truth collide.
Very good. All right. Bond continues. Thank you. Court does call the case People versus Stephen Grisbeck.
Assistant Public Defender Chelsea Vergils with and on behalf of Stephen Grisbeck on cases ending in 1354 and 5176.
Morning, Your Honor. Sam Bernstein on behalf of Mr. Grisbeck on 11.
What are we doing?
Stephen Grisbeck.
Your Honor, we're asking to adjourn, I believe, on all cases. We're trying to see if we can reach a global resolution. I would also ask the court to consider a release to treatment. I believe he already has that on 1354. We're asking for that as well on 5176.
I just heard bells while you were speaking. You want release to treatment. If you prepare an order, should be stipulated to send it to me. I'll sign off on it.
Okay, thank you, Your Honor.
All right. And what are we doing on yours?
Likewise, Your Honor, asking for an adjournment to try.
Okay, timing wise, you're trying to do a global resolution, but there's other cases in circuit. When are those?
No, there's no other case in circuit, Your Honor.
It's just these.
Yes, Your Honor.
He is currently serving a sentence, but a motion should be forthcoming regarding the request for release to treatment on that.
The 30th, will that work?
Yes, Your Honor.
Matters will be adjourned to September 30th. 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls case of the People versus Philip, is it DiPatrizio?
DiPatrizio, Your Honor.
DiPatrizio, is that what I said?
That's what I thought.
Okay.
Your Honor, good morning. Joe Simon on behalf of the defendant. State your name when you go.
Philip DiPatrizio.
Thank you.
And Your Honor, we're asking this matter be set for exam as well.
Cover is complete.
Yes.
People have their witnesses available the 23rd.
Request, Your Honor.
Preliminary examination in this matter will be set September 23rd, 2025, 9 a.m. That is before Judge Barr. Bond will continue.
Thank you, Your Honor.
Thank you.
You can go home. All right, we'll see.
Court does call the cases of the People versus Kevin Davis.
Morning, Your Honor. May it please the court, George Lyons on behalf of Mr. Davis in both files.
Morning, sir.
And respectfully, my client, Your Honor, after having discussed this with him, and the people will be waiving his preliminary examination, Your Honor.
Yeah, waiving on both cases.
On both files, Your Honor. He knows and understands his right to a preliminary examination. He also understands the burden that the people have, that by waiving this, the matter will be bound over the circuit court for ultimate resolution. He's affixing his signature to the waiver on both files.
Sir, is all of that correct?
Yes, sir.
You understand that the preliminary examination which your counsel speaks about you will not have in this matter will be sent to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived in both matters. Defendant is bound over to circuit court on both counts.
Rhonda, before the fixes the signature to the bond, may I address or ask the court to reconsider the bond, my application for bond modification I made last time? Respectfully ask the court to consider something that includes a tether to his parents' home in Albion, Michigan, where he was raised. And
Pardon?
may the court consider a tether to his parents' home in Albion, where he's from. Mom and dad are here, Your Honor. The allegations here took place some time ago when my client was a teacher here, Your Honor, I believe 8 years ago. 6.5 years ago. Your Honor, the people's objection is that he was living in Florida. Well, he doesn't live there now, Your Honor. He respectfully living in Michigan until this matter is resolved. He is a Michigander, Your Honor, so perhaps not a Michigan fan.
Response.
I believe his bond is appropriate as set. Nothing has changed since the last time this motion was made. He was extradited from Florida. It is correct that these allegations took place some time ago, but I have concerns that there are two separate victims. Both took place while they were minor students, and the defendant was their coach.
May I respond to simply say my client didn't?
I thought I already ruled on this, but go ahead.
My client didn't. The court did, Your Honor. But my client did not abscond to Florida. He moved there to take it for his wife had a job there, and he was down there. I think actually applying to the police force down there. So this isn't an absconding case where he and his family actually moved to Florida. May I approach with the signed waivers?
Anything else from either side?
No.
It sounds like the same argument, so it's going to be the same for bond reduction is denied. Thank you. As to the Circuit Court Arraignment Council.
Yes, Your Honor.
You waive formal reading of the information.
Yes, we do, Your Honor. He'll be standing mute.
Defendant having waived formal reading, standing mute as to all four counts. Court will enter a not guilty plea. Pretrial in these matters will be set for
September 22nd at 1:30 with Judge Hammoud.
September 22nd, 2025, 1:30 before Judge Hammoud.
Thank you, Your Honor.
Bond will continue. Thank you.
Your Honor, may I approach and sign the information?
Yes, you may. Court calls the case People versus Lawrence Patrick.
Ready, Your Honor. Trevor Mayville for the people.
Lawrence, how would you? And Joe Simon on behalf of Mr. Peck. Didn't hear that.
Lawrence Peck.
Thank you.
Your Honor, we adjourned this once before to allow another charge to ripen, which it has, which is an OWI second before Your Honor next week. They arise out of the same incident. My client is now, I've informed the people, he's interested in entering the 14A sobriety court, and I'm arranging for him to be screened for that process. I'm asking the court to adjourn this probable cause conference probably around 3 weeks, if the court would entertain that.
Weeks. I had the 30th of October.
Just to be safe, it's probably the latter date is the.
Any objection from the people? We adjourned October 9th, 2025, 9 a.m. Bond will continue.
Thank you, Your Honor.
Thank you.
Thank you.
Court does call the case People versus Anthony Williams. In case. How many AG cases, Joe?
Just two. Good morning, Your Honor. Assistant AG Clarissa Williams.
Assistant Public Defender Chelsea Vergil is with and on behalf of Anthony Williams. Please state your name.
Anthony Williams.
Your Honor, I'm asking for, if possible, 1 week adjournment. I did receive an offer from the Attorney General yesterday after I was speaking with Mr. Williams. So just to keep things moving along, asking for a very short adjournment.
1 week would be the 18th. That objection, probable cause conference, September 18th, 2025, 9 a.m. Bond continued. Thank you.
Thank you.
Court calls case People versus Brandon Kelly.
Assistant Public Defender Chelsea Vergils with and on behalf of Brandon Kelly. Mr. Kelly, can you unmute and state your name?
Yeah. Yeah, let me see if I got it. All right, Brandon Kelly.
We're asking to adjourn this for media, and may I address bond?
Probable cause conference will be adjourned to September 25th. Yes, Esteban.
We are asking the court to consider a personal bond or a very low cash bond. Mr. Kelly has a plan for, if he's released, he would stay with his parents. He also would be in treatment with CMH. He does not have a criminal history, understands his bond conditions, and I think it would be beneficial to him to get that mental health treatment out of custody. He has been in custody for 70 days now.
Only on this case?
He had another misdemeanor. My understanding was that the bond was set at $100 on that just to get time served.
He does have another case. I'm sorry, I don't know if the counsel is finished. It's completed there.
I'm finished. Thank you.
So, Your Honor, we do believe that Mr. Kelly still is a danger. With Mr. Kelly, while it is true that he has a CMH plan, it's the result of being petitioned while he was in jail. That petition last month because he was threatened to kill a jail staff member, to injure jail staff. He refused to take any medication. Your Honor, it was indicated that I checked the record of actions. He just had his hearing 2 weeks ago. And at that hearing, he was found to be a person in need of treatment, that he, one, is a danger to others, and also doesn't necessarily recognize the amount of treatment that he needs. And
That treatment is completed.
Okay, thank you for interrupting. Go ahead, Mr. Douglas.
So, Your Honor, I know in the petition that it did indicate that the petitioner was recommending that the jail be able to give Mr. Kelly shots of antipsychotic medication since he would not take medication. And so while I'm sure in the last 2 weeks, he might be benefiting from that medicine, I feel about whether he will continue that medication once he's released. The allegations here, I think, indicate a danger to the public. If there had been some ongoing treatment that he seemed cooperative with, I would feel different. But in this case, he's accused of punching a Target employee in the face where he busted his lip by using a watch wrapped around his knuckles as a makeshift metal knuckles. I would also note that in the other case, he's accused of following a stranger to a library bathroom. When that individual turned around to find out why Mr. Kelly had followed into the stall, Mr. Kelly asked him what he's looking at, and then he punched that individual in the face, giving him a black eye. So with such a short amount of treatment, given that he's had a history of non-compliance, I don't think at this time that it's safe for the public.
Anything else?
I would just say we're not denying that he has had, mental health struggles, and he is going to get help with that. I think that the circuit court order for assisted outpatient treatment is a determination that it is appropriate for him to be getting outpatient treatment rather than being hospitalized or some more restrictive alternative. I also think with a supportive family, he would do well in that environment. So we still ask the court to consider that.
Motion for bond reduction is denied. Bond will continue. Thank you.
When's the next court date?